Hello. Welcome to our channel. This is Dr. Olu Asekun here. Thank you for joining us again. Today is another Wednesday, the 23rd day of May 2023. You're welcome. This podcast is to enlighten our people. This is to provide information, free information to people all around the globe so as to prevent avoidable mistakes, avoidable errors. So join us today. Invite your friends, invite your family so that you can be a beneficiary of this free session. We do this every Wednesday, 12 p.m. Dallas time, that is 12 p.m. Central Standard Time, that is 1 p.m. Eastern Time, and that is 10 a.m. Pacific Time, and of course that is 6 p.m. Nigerian Time. Okay, so invite your family, join us, and as soon as we start, you can start sending in your questions. You can call in to ask questions. You can text to ask questions. You can also send questions through WhatsApp. We will read the questions and then we will answer it. That has been the pattern, and that is what we intend to continue doing today and going forward. So you are welcome today. A couple of weeks ago, or maybe last month, I think, we started discussion on removal defenses. We started conversation on removal defenses. If I recollect correctly, we have discussed asylum in removal defense. We have discussed cancellation of removal for non-permanent residents. We have discussed cancellation of removal for legal permanent residents. If I recollect correctly, we have discussed victims of abuse and violence as a form of defense in removal proceedings. So today, we intend to continue the removal defenses, and today we'll be discussing what is called 237A1H waiver. 237A1H waiver. Today's topic is what I called advanced immigration discussion. Advanced because this is a very, very technical, and not many people are familiar with this. Not even many lawyers are familiar with this defense. It is called 237A1H waiver. It's a form of defense that is available, or a relief that is available to someone who has already obtained permanent resident status. In other words, this relief is only available for someone who has already obtained a green card. But this is different from cancellation of removal for legal permanent resident. It is different because this waiver, this defense, or this relief is specifically available for people who obtain their green card by fraud. People who obtain their green card by fraud. Now, talking about obtaining green card by fraud, definitely if immigration is aware at the time of approval of the green card that the application is fraudulent, immigration will not approve it. So usually this is a situation where people obtain green card before immigration found out that the green card was obtained fraudulently. In fact, majority of the time, it is when an applicant or a respondent apply for citizenship, that this issue usually comes up. And it may be that during citizenship, immigration decided to look more closely into the green card itself. And then they realized that, oh, this particular green card was obtained by fraud. In most cases, they would deny the citizenship application and then put the respondent into removal proceedings. Of course, if that happened, the NTA, the notice to appear, will have as one of the allegations in the removal proceedings, the allegation that the respondent or the applicant obtained the green card by fraud. So, if you are a legal permanent resident and you have been accused of obtaining your green card by fraud, or even if you have not been accused, but if for any reason you know that your green card was obtained by fraud and you now have this concern that you may ever be able to apply for citizenship, well, this 237A1H waiver may be available for you. It's a form of relief that is specifically designed for people who obtain green card by fraud. So, that is what we'll be discussing today. I want you to start sending your questions. Start sending in your questions so that we'll be able to answer those questions as the questions are coming in. Now, talking about obtaining green card by fraud, talking about 237A1H waiver, there are categories of fraudulent activities. But as far as immigration law is concerned, fraud is fraud. The intent may not be material to the determination of eligibility. What that means is that whether the fraudulent activities was intentional or it was an act of ignorance, that will really be immaterial as far as immigration is concerned. The law does not separate or distinguish between somebody who committed fraud intentionally and somebody who committed fraud out of ignorance. The law does not distinguish between the two. However, when it comes to establishing, when it comes to discretionary matter, those actions may be considered by the adjudicator, that is, by the immigration judge. Someone whose fraud was as a result of ignorance. Of course, when it comes to matter of discretion, the judge is going to take that into consideration. In the same vein, somebody who committed the fraud intentionally, that will also be a factor that the trial of fact or the judge will consider in determining in making a decision whether or not to approve the waiver under 237A1H statute. Now, let me give you a couple of examples to distinguish between fraud that are intentional and fraud that are out of ignorance. Example of fraud that is intentional is somebody who committed marriage fraud. If you enter into a marriage under an arrangement, under a contract, a marriage that is not legit, a marriage that is not with the sole purpose of living together for love, a marriage that was entered into primarily just to get the green card. And if you succeed in getting the green card, and then maybe along the line, maybe when you apply for citizenship, or even maybe the petitioner or the beneficiary along the line took some steps that caught the attention of immigration, and along the line they found out that the marriage was never intended to be a real marriage. That is an intentional fraud, because that means that at the time of entering into the marriage, you knew that you are going into this primarily just to get the green card. So that is an intentional fraud. Again, it does not affect eligibility. Whether the fraud is intentional or the fraud is out of ignorance, it does not affect eligibility. But fraud is fraud as far as the law is concerned. However, the reason I'm making the distinction is when we get to the area of discretion. Of course, every factor that led to the fraud will be a consideration by the adjudicator, by the immigration judge. The immigration judge is going to look at whether this was something that was done as a design, or whether it was something that was one-off, or whether it was something that was out of ignorance. Of course, that will play a part in the judge's determination when it comes to discretionary matters. Now, the requirement of the law is both statutory and discretionary. They are both statutory and discretionary. But before I go into that, I want to explain the second part of fraudulent activities, that is fraud that could be a result of ignorance. Let me give an example. Let's say a US citizen petitioned for an unmarried child who is over 21. A US citizen petitioned for an unmarried child who is over 21. Now, if that child gets married before that child becomes a permanent resident, it does not matter whether the petition has been approved. It does not matter whether the beneficiary is inside the US or outside the US. If that child gets married before the child becomes a permanent resident, that petition becomes void. That petition becomes void. So, the category, if the petitioner at that time was already a US citizen, the category will change. The category will change from US citizen petitioning for unmarried child to US citizen petitioning for married child. So, if the beneficiary is outside the United States and the beneficiary got married before becoming a permanent resident, and that information was not disclosed to immigration, along the line, if immigration becomes aware of that information at any stage, that green card becomes void. So, such a beneficiary actually obtained the green card by fraud. Even though that fraudulent activities may be as a result of ignorance, it may be that the beneficiary did not know that getting married may invalidate the approval of the I-130 petition, the relative petition. So, because this is what we have seen all the time. Most of the time, when this type of fraud occurs, it is actually out of ignorance. The beneficiary will say that, oh, I didn't know that getting married could actually invalidate the approval. In fact, in most cases, beneficiaries get married after obtaining immigrant visa at the embassy. In fact, I've seen so many cases where the petition was filed for an unmarried child over 21. Now, the beneficiary will complete the entire process. After immigrant visa had been issued to the beneficiary, at the embassy. But before entry into the United States, most times the beneficiary will go ahead and marry their spouses or their fiancé. Most of the time, especially from African countries, it is as a result of pressure that, oh, you are going to America now. Once you leave, once you go, our relationship may be in jeopardy. So in order to be secured, in order to be safe, now that you have gotten your immigrant visa, we can go ahead and get married. And then they will go ahead and get married. Most of the time, these fraudulent activities are carried out as a result of ignorance, not because they actually intended to commit a fraud. But as I said, the law does not distinguish between fraudulent activities that resulted from ignorance versus fraudulent activities that was intentional. As far as fraud is concerned, fraud is fraud. Because if the petition was based on the fact that you are an unmarried child of a US citizen and then you got married and you fail to notify the authorities that you are married, then it becomes fraud. So it means that the green card is still not valid. But because the most of the time the beneficiary always get married after obtaining immigrant visa, so immigration may not know until much later. Maybe eventually the beneficiary entered the United States, decided to file a petition for the husband now. Again, at this stage, they will have to submit a marriage certificate. The marriage certificate will show the date of marriage. So usually immigration will find out that this person actually got married before entering the United States, in which case the green card was obtained by fraud. So in such a situation, they can go ahead and put the beneficiary in removal proceedings. But in some cases, if the only thing that was filed is the I-130 petition, immigration may not even put the beneficiary in removal proceedings. They may wait for the beneficiary either to apply for citizenship or wait until the green card expires if the beneficiary chooses not to apply for citizenship. But whenever the beneficiary has a contact with the immigration authorities and then they found out that the beneficiary actually got married before entering the United States, then they will make a determination that the beneficiary in such a situation obtained the green card by fraud, and then they can deny the relief or the benefit that the beneficiary is seeking and then put the beneficiary in removal proceedings. So if you ever find yourself in this scenario, of course, we can help you. That is something we have done over and over and over again. We have done it over the years. We have also helped some of our professional colleagues on how to handle this particular area of law. So, in such a situation, you may be eligible for 237A1H waiver, which is what we are discussing today. 237A1H waiver. Please start sending in your questions. As I said, this is going to be a very technical area of law. So send in your questions so that we do not waste a lot of time before answering questions. So start sending in your questions. So for a recap of what I've said so far, the 237A1H waiver is a form of relief or a form of defense that a respondent who is in removal proceedings can actually present to the immigration judge in order to have his or her green card revalidated. Now, if a 237A1H waiver is granted, it has the effect as if the offense never happened. So what that means is that it is similar to what I can call pardon in criminal law. It is similar to a pardon in criminal law. We know that in criminal cases, when somebody committed an offense, even if the person has been convicted, if the governor or the president, depending on whether it's a state offense or a federal offense, if the governor or the president decide to pardon the person, it will erase the offense completely. So it will have the effect as if the offense never happened. So it is the same exact way that 237A1H waiver works. So if somebody obtained green card by fraud and then the court or the immigration judge decide to grant 237A1H waiver, the effect will be as if the person never committed any fraud in the first place. So what that means is that if the person has previously accrued the number of years to be eligible for citizenship, upon the grant of this waiver, the person can go ahead and submit application for citizenship. Unlike most other reliefs, in most other reliefs, the respondent will have to start eligibility all over again. In other words, if someone apply for cancellation of removal and then the cancellation of removal is granted, from the date of the grant, the applicant will now have to wait either 3 or 5 years, depending on the category, before being eligible for citizenship. But in the case of 237A1H waiver, if the person has been a permanent resident, let's say for 3 years before or 5 years, maybe the person actually applied for citizenship before the fraud was uncovered and then the person got into this situation. If this waiver is granted, if it is granted today, the person can actually apply for citizenship today if the person previously met the requirement for citizenship. So that is why I said it has the effect similar to pardon in criminal cases. So that is what this 237A1H waiver is all about. Okay, I think we started having questions. I will still explain more, but I think it's better to spend a lot of time answering questions so that we will not waste too much time. Is there a form to fill out for this waiver? No, there is no form. This is a procedural. When I started this session today, I explained that this is one of the most technical areas of law. This is something I am not even sure that a respondent will be able to navigate this pro se. I think the best bet will be for a respondent who believes that he or she is eligible for this relief to seek counsel or to seek guidance from an experienced immigration attorney. But no, there is no form to be filled out. This is not one of those applications that you fill a form. Next question. How does someone apply for the waiver? Again, like I said, it is a technical thing. There is a package that has to be presented, and usually it is advisable that you consult an experienced immigration attorney who can really help with this type of waiver, because it's very technical. It's not something that when we go into the details of the requirement, you will understand why it is technical. It is more about law. It is not a whole lot about completing a form or anything. No, it is more about law. And that is why, even from the title, 237A1H, that is the section of the Immigration and Nationality Act that deals with this waiver. So there is no form for it. So advise, consult an experienced immigration attorney who can help you navigate this waiver. Can someone receive this waiver even if USCIS, DHS, EOR does not actually know? that the card was received by fraud? No, you cannot, because one of the major requirements is that the green card must have been obtained by fraud. That is a statutory requirement. When I go into the requirement, we'll discuss that. That is a statutory requirement. Or maybe I should hold on. um Maybe I should hold on and explain it further before before I start answering questions, so that some of these issues may be dealt with more clearly. Now, let's talk about the requirement for this waiver. The requirement for this 237A1H waiver. The requirement falls into two parts. I will call it Part A and Part B. So talking about Part A I will term statutory, and Part B I will term discretionary. As we already know, anything that is statutory is mandatory. America is a country of law. Nobody is above the law. Nobody can actually go against the law in this country. So when the law states that ABC must be provided, that is statutory. It means it cannot be waived. It means it cannot be a matter of discretion. So that is statutory. So the Part A requirement is the statutory requirement. So what the statutory requirement says for Part A is that, one, the applicant or a respondent who is applying for 237A1H waiver must have obtained the green card or the permanent resident status by fraud. That is a statutory requirement. So if immigration is not aware that you committed a fraud, you will not be eligible for this relief. Of course, immigration may not be aware, but you may be the one to notify them. If you know that you are eligible for the relief, you can notify them that, look, I committed this fraud, I obtained my green card through this fraud, I want to apply for 237A1H waiver. But again, you can only apply when you are in removal proceedings. Remember, the topics we have been discussing for weeks now, we are discussing removal defense. So this is defensive relief. It's not affirmative. It is not something you can send an application to USCIS to say you want to apply for 237A1H. USCIS may not even understand what you are saying. So this is not an affirmative issue. It is a defensive issue, because we are discussing defenses in removal proceedings. So that is why we are discussing this. So it is not something that is available with USCIS. It is only available when someone is in removal proceedings. So going back to the statutory requirement, the first statutory requirement is that an applicant or a respondent must have obtained the green card by fraud. That is the first requirement. Now, the second statutory requirement is that the applicant who obtained the green card by fraud must have a qualifying relative. I've explained this in several of our podcasts, but for the purpose of those who are joining us for the first time today, what does qualifying relative mean? Qualifying relative, for the purpose of immigration law in the US, it means that somebody must have a family member who is either a US citizen or a permanent resident. Somebody must have a family member who is either a US citizen or a permanent resident. Now, talking of family member, family for the purpose of immigration law is different from family for the purpose of English dictionary. So when we are talking about family for immigration law, it only includes the parents. The parent, that is the father and the mother. The parent, it includes spouses, that is husband or wife, and then it includes children under 21, minor children. So it is different when we are talking about family under English dictionary. This is family under immigration law. It means children under 21. So if you have a US citizen child who is over 21, that such a person will not qualify as a qualifying relative for the purpose of a waiver. Now, a US citizen child who is over 21 is considered an extended family member for the purpose of this waiver. A US citizen child who is over 21 is considered extended family member for the purpose of this waiver. So when we are talking about qualifying relative for the purpose of this waiver, we are talking about your parents, we are talking about your spouses, and we are talking about minor children under 21. They can either be US citizen or legal permanent resident. Now, if the fraud that formed the basis of your ineligibility, if the qualifying relative is the source or is part of that fraud, then that qualifying relative cannot serve as a qualifying relative for the purpose of this waiver. In other words, if you married somebody fraudulently in order to get green card and you succeeded in getting the green card before the fraud was discovered, you cannot use that same fraudulent marriage. You cannot use the same fraudulent spouse as a qualifying relative for this purpose. So if you are talking of qualifying relative, it has to be somebody different. It cannot be the same fraudulent wife or fraudulent husband. So it has to be somebody else who will qualify for this purpose. Now, before I go further, something is very important that I explain something. For the purpose of those who have listened to prior podcast where we discussed waivers, usually when we discuss waiver, when we discuss qualifying relative, we always talk about proving hardship to qualifying relative. In this particular case, in this particular 237A1H waiver, proving hardship is not required. I want you to pay attention. This is one of the major differences and one of the major benefits and one of the major reasons why this waiver is so easy to obtain. There is no requirement of proving hardship to any qualifying relative when we are talking about 237A1H waiver. The statutory requirement, I'm still on the part A, that is talking about the requirement. The statutory requirements are only two. And one, you must show that you obtained the green card by fraud. Two, you must have a qualifying relative. All you need to do is just to have it. You don't need to prove any hardship to anybody. You don't need to prove hardship to yourself. You don't need to prove hardship to your qualifying relative. You don't need to do anything. All you need to do is to show that, one, you obtained the green card by fraud, and two, you have a qualifying relative who is either a US citizen or a permanent resident. It's as simple as that. No need to prove any hardship to qualifying relative. In fact, I can tell you authoritatively, this is the only waiver in the entire Immigration and Nationality Act. This is the only waiver where hardship to anybody is not required. In most waivers, you either have to prove extreme hardship to qualifying relative, or you have to prove exceptional, unusual hardship to qualifying relative, or in some limited situation, to prove hardship to yourself, especially in situations where you are a victim of violence or victim of abuse. You may need to prove hardship to yourself. But in this particular 237A1H waiver, there is no requirement of proving hardship to anybody. The qualifying relative is not required to show evidence of hardship. The respondent is not required to show evidence of hardship. All you need to show statutorily is to show that, one, you obtain your green card by fraud, and two, you have a qualifying relative. It's as simple as that. Those are the statutory requirements. Again, we are talking about the United States of America here. We are talking about a country of law. We are talking about the requirement of law. So automatically, once you meet the statutory requirement, except you have some major challenges, except you have some major adverse factors, except you have a major negative equities. Usually, once you meet the statutory requirement, 90% of the time, the waiver will be granted. That is part A. Now, let's go to part B. Part B is discretion. Part B is discretion, discretionary consideration. Now, this is where the judge, the immigration judge, has the power to use his or her discretion to determine your desirability as a permanent resident. If you listen to some of our previous discussions on this podcast, you will see that we have mentioned in the past that I-485, application to register permanent resident or adjust status, that is application for green card, is a discretionary form of application. It is one of those applications that does not have provision for appeal. So if an I-485 application for adjustment of status, if it is denied, there is no provision for appeal. The reason there is no provision for appeal is because it is a discretionary relief. So, having said that, the B part of the waiver requirement, this 237A1H waiver, is the discretionary aspect. The immigration judge has a discretionary authority to make a determination whether anybody applying for green card is desirable to be a permanent resident of the United States or not. So usually, how is discretion determined? This does not mean that the judge has the ultimate power of life and death. No, that is not what it means, because even though it may be discretionary, but there are guiding principles, there are statutory guidelines, or maybe I say what I would say case law guidelines of what the judge must consider, what the judge must look at. So usually what the case law says is that the judge must weigh, they must put the positive equity and the negative equity, they must place both of them on a scale of justice, and make a determination which of them outweigh the other. Is it your positive equity that outweighs the negative equity, or is it the negative equity that outweighs the positive equity? So the judge, this is where discretion comes in. The judge will weigh all your activities. Again, this is where there is a distinction between somebody who committed fraud out of ignorance versus somebody who committed fraud intentionally. The judge may consider somebody who committed fraud intentionally, the judge may add that to the list of negative equities. Somebody who committed fraud out of ignorance, the judge may not add it to list of negative equity. So this is where discretion comes in. This is where individual personality of the judge matters. This is where personal experience of the judge affect the ruling. This is where what the lawyer did or what the lawyer failed to do affect the judge's decision. This is where discretionary matters comes in. Now, let's look at more questions before we proceed. There's still a lot to explain, but let us answer some of the questions. Can someone receive this waiver even if USCIS, DHS, EOR does not actually know that the card was received by fraud? I think I already answered this. You cannot receive the waiver because out of the two statutory requirements for the waiver is that the person must show that he or she obtained the green card by fraud. So even if they didn't know, because you have to disclose it, then they will become aware of it. So you cannot get the waiver if they are not aware of the fraud. Next question. Is the waiver only for LPR? Can a conditional resident receive it? Well, yes, the waiver is only for permanent resident. It's only for permanent resident because a conditional resident is different from a permanent resident. This waiver is only for permanent resident. 237A1H waiver is only for legal permanent residents. Having said that, you see, this is one of the reasons why I enjoy this work. The best thing that can happen to anybody anywhere in the world is to love what you do. Is to love what you do on daily basis. Because if you don't love what you do, you get frustrated. If you don't love what you do, you get discouraged. If you don't love what you do, you get easily upset or irritated and you give up easily. This question that this person has raised, it brought my attention to something. Actually, statutorily, the law did not mention conditional resident. But guess what? I think it is a gray area. I think if you know that you will be eligible for this relief and you are a conditional permanent resident and you do not have any other relief, if I were in your shoe, I will go for it. It is always good to have a precedent. If you don't try something, it may never happen. I did a case in San Antonio this week. Today is Wednesday. I did a case on Monday, 2 days ago, where I presented an argument that has not been presented before. And guess what? To God's glory, my client is a permanent resident today because that argument succeeded. It's an argument that has never been presented before. I didn't have any precedent for it, but I just believe that this argument is worth making. And guess what? I succeeded. So, this is worth making too. The law did not list conditional resident for this waiver, but at the same time, the law did not exclude them. So, why not give it a try if you are in such a situation and if you don't have any other relief? Because if you have other relief, you will not want to test the waters, because if it does not work, you may be ordered removed, because this is a relief that you are seeking at the immigration court. Okay, next question. Part 1 of I got my green card through DV visa lottery. When I applied for the visa lottery, I did not disclose that I had a child. I then won the visa lottery and came to the US. After 5 years, I applied for citizenship and got denied because I added my child's info in the form. I was denied because of it, because I failed to disclose this info before. Is this considered fraud? Yes. The answer is yes. This is actually one of the scenarios where 237A1H waiver will work perfectly. The answer is yes. But of course, you have to meet other requirements. You have to meet other requirements. Okay, final part of it. If I'm placed in removal proceedings, will I be eligible for this kind of waiver? I already answered it. The answer is yes. Yes, this is perfect for this waiver. The answer is yes. You will be eligible for this relief if you are placed in removal proceedings. And you will not only save your green card, and like I said, if the waiver is granted, you can apply immediately for citizenship again. And you will be able to get your citizenship, and you will also be able to petition for the child that you didn't disclose. Yes, this waiver is perfect for this question, for this scenario. The answer is yes. Okay, next question. Is it possible that an immigration judge will not know about this waiver? I know someone whose attorney tried to get it and the judge kept insisting that there was a form. Well, I can't comment on what other lawyers did or what they didn't do, but this 237A1H waiver is something that I've done over and over and over again. In fact, I have gotten the waiver even this year. It's not something that is I'm not talking from old perspective. I've been doing it in the past, and I still do it currently. And there is no form for it, but there is a package. There is a way it is packaged. So I don't know what the lawyer presented. I don't know what the lawyer did or what the lawyer did not do. So that's not something within my jurisdiction, since I have no idea what happened in court. But I can tell you the waiver 237A1H waiver is a waiver that does not have a form. There is no form required for the waiver, but there is a package. There is a way the waiver is packaged and presented to the immigration court, and a copy served to the opposing counsel. Next question, and I will find it difficult to say that an immigration judge will not know about the waiver. That would be almost impossible, because even if the judge didn't know before your lawyer raised it, after the lawyer raised it, I'm sure that the judge will look into their resources and find out how it works. So I don't know. I can tell you that your lawyer is probably the one not doing something right. But again, I'm not going to comment on what other people do or what they fail to do. But it's a waiver that does not require a form, and it's a waiver that we file all the time in our office here, and we get it approved to God's glory all the time. Next question. I'm a VAWA self-petitioner and was able to get my green card. Now it was determined during citizenship interview that I obtained it fraudulently. I don't have a qualifying relative, but I have read that I don't need one because it's VAWA. How true is this? This is absolutely untrue. Absolutely untrue. If you are applying for 237A1H waiver, there is a statutory requirement that you have a qualifying relative. So that is absolutely untrue, except you are talking about other forms of waiver. But if you are talking about 237A1H waiver, it is a statutory requirement that you have a qualifying relative. Your qualifying relative does not need to show any hardship, but you must have a qualifying relative. It's a statutory requirement. Second part, okay, part one. I was admitted as an unmarried child above 21 of a permanent resident, but I was actually married. I applied for citizenship and USCIS found out. I'm now in removal proceedings. From what you are saying, I believe I may be eligible. Can my mom be my qualifying relative when she is the one that filed for me? Well, this question is a little technical. Is a little technical. This is not one of those yes or no questions. And I'm going to take time to explain why it is not one of those yes or no questions. This example was similar to the example that I used when I was explaining 237A1H waiver. But I want you to understand that there is a big distinction between a legal permanent resident and a U.S. citizen. There's a big distinction. When I was explaining this at the beginning, I did explain that if an unmarried child of a U.S. citizen got married before becoming a permanent resident, such a person, the I-130 petition will change category. The category will change from a U.S. citizen petitioning for unmarried child. The category will change to U.S. citizen petitioning for married child. Now, that is a change of category, but the I-130 petition, the approved petition, will still be valid. What will change is the category. There will be additional time, except visa is current in that second category, which is U.S. citizen petitioning for married child. If visa is not current, the beneficiary will have to wait until visa becomes available. Now, it is not the same with permanent resident. In the case of permanent resident, the moment the beneficiary gets married, that petition is terminated by operation of law. Whether immigration is aware or not, by operation of law, that petition is terminated. The petition cannot change. The category cannot change. There is nothing to change to, because when you look at the differences between a permanent resident and a U.S. citizen, a U.S. citizen can petition for a spouse. Permanent resident can also petition for a spouse. A U.S. citizen can petition for minor children under 21. Permanent resident can also petition for minor children under 21. A U.S. citizen can petition for unmarried child over 21. Permanent resident can petition for unmarried child over 21. That is where the similarities end. Now, a U.S. citizen can petition for married child over 21. Permanent resident cannot petition for married child. And because a permanent resident cannot petition for married child, that petition cannot change category because there is nothing to change to. You cannot give what you don't have. So there will be nothing to change to. So that petition is terminated by operation of law. It cannot be converted to a different category. Now, a U.S. citizen can petition for siblings, that is brothers and sisters. Permanent resident cannot petition for siblings. A U.S. citizen can petition for fiancé. Permanent resident cannot petition for fiancé. A U.S. citizen can petition for parents. Permanent resident cannot petition for parents. So there's a wide range of things that a U.S. citizen can do that a permanent resident cannot do. So for this reason, one of those things that permanent resident cannot do in this case is to petition for a married child. And because a permanent resident cannot petition for a married child, so if a child gets married before becoming a permanent resident, that petition terminates by operation of law. Now, if you are now placed in removal proceedings, are you eligible for 237A1H waiver? The answer is yes. The answer is yes, you are eligible. Can your permanent resident mother or father be your qualifying relative? Yes, your permanent resident father or mother can be your qualifying relative. So I believe that I've answered this question extensively. Okay, that seems to be the last question for now. So keep the questions coming in. Keep the questions coming in. Yeah, that is the last question that we have received for now. Keep the questions coming in. Remember to invite your family and friends. It is not going to be, it will be unfair for you to keep receiving this free information, free knowledge, free all these things we are doing for free, and then you keep it to yourself. If I decide to keep it to myself, then I will have all the knowledge to myself. But I'm sharing the knowledge with you, so it is also good for you to let others benefit from this. You never know who may be a beneficiary of all this information we are passing out free of charge. Ordinarily, if you come to our office for consultation, you know how much money you will pay before, and you may pay it and not even get 1/10 of this information we are passing out free of charge, because we will only address whatever questions you raise during consultation. But we are doing this for free. We are not doing it for any monetary gain. We are not doing it for any recognition or anything. We are just doing it as a way of giving back. As a way of giving back. The Almighty God has blessed me so much, and I believe that I owe humanity to share part of my knowledge, to share with people, and that is why we are doing this. So the only thing you can do to encourage us, to keep us going, is to share this information with your family and friends. Invite people, invite your friends, so that other people too can benefit from this. Don't be selfish. Don't keep it to yourself alone. Subscribe to our channel so that when we go live, you get notification, and you will also have reasons to thank God for listening to this session. So keep the questions coming in. I think there's a question before I go on to further explain the B part of the requirement, which is talking about the discretionary requirement. Let's quickly read this question. What factors do immigration judges take into consideration when reviewing 237A1H waiver? Well, this is one of those questions that is really difficult to answer, because whoever sent this question, if you understand what we have explained so far, it will be easier for you to determine what to present. But what I'm going to tell you, as I've said at the beginning, there are two types of requirement. I categorize one as statutory, and I categorize the other as discretionary. So the statutory requirement cannot be waived. It is statutory. We have to comply with the law. This is a country of law. It cannot be waived. So the two statutory requirements: one, the respondent must have obtained the green card by fraud. That is the statutory requirement. The second statutory requirement is that the respondent must have a qualifying relative, and I've explained what qualifying relative means. And I also explained that if the qualifying relative was part of the fraud, then the qualifying relative cannot meet this requirement, because if the qualifying relative is part of the fraud, then that would be like rewarding the qualifying relative for committing a fraud. So the qualifying relative will not be able to meet the requirement. And to further explain it further, I explained the distinction between somebody who committed fraud out of ignorance versus somebody who committed fraud innocently. So if you look at one of the previous questions that I answered, somebody who raised question about her mother being a permanent resident and he getting married without disclosing to immigration whether the mother could be a qualifying relative. In such a situation, yes, the mother could be a qualifying relative, because that is not a clear-cut case of a mother perpetrating a fraud or getting involved in fraud, because such a thing may happen out of ignorance. For example, both the mother and the beneficiary may not know that getting married will terminate that approved petition. That may be a fraud that was committed out of ignorance. So, in such a situation, the court will not disqualify the mother from being a qualifying relative. But that would be different from somebody who committed marriage fraud. Somebody who entered into a marriage knowing that it was not for love, knowing that it was just for the purpose of getting green card. So if such a person is going to apply for 237A1H waiver, the fraudulent spouse cannot meet the requirement. So it is very important that we understand the distinction. The fraudulent spouse cannot meet the requirement of this statutory requirement. So the statutory requirement, the green card must have been obtained by fraud, and 2, there must be a qualifying relative. The respondent must have a qualifying relative. Okay, now talking about, I thought there was another question, but I think that was still the last question. Now, talking about that is the statutory requirement of the waiver. Now, the discretionary requirement of the waiver, I explain again that here the judge will put both the positive and the negative equity, put both of them on a scale of justice, and then determine which one outweigh the other. So if the positive equity outweigh the negative equity, then the judge will take that into consideration and approve the waiver. If the negative equity outweigh the positive equity, that may be a factor that the judge may consider in making a determination whether to approve or deny the waiver. Now, talking about positive equities, talking about equities generally, I'm going to talk about both positive and negative equities. Talking about equities generally, one, okay, let me talk about positive equity first. The length of time the applicant or the respondent has spent in the United States, that may be a positive equity. If the respondent has been here for years, maybe like 4 or 5 years, and out of those 4 or 5 years, has he been a responsible member of the society? I mean, if the respondent has been a permanent resident for 4 or 5 years, has the respondent been paying his or her tax annually, or is the respondent owing tax to IRS? If the respondent is owing tax, that may be something that the judge may consider as negative, because every adult living in the United States has a responsibility to file annual tax return. So if you are here and you have failed to file your tax return, that may be seen by the judge as something negative on your part, and they may believe that if they grant you the waiver and make you a permanent resident or a U.S. citizen, an alien can continue the irresponsible act of not filing tax return. So that may count as negative equity. Secondly, does the applicant or the respondent, do they have criminal record? If you have been here and you have been committing crime, again, that will go into your negative scale. That will go into negative equity. It means that if you have been committing crime, it means that you have no regard for the law of the land. And if you do not have regard for the law, why should they give you benefit for it? I mean, I know someone who entered the United States. He didn't really have a criminal record, but he was getting tickets virtually every month. I mean, he was getting tickets for almost on monthly basis, even though he didn't have criminal record. But in such a situation, the judge will still consider it as negative, because if you keep doing the same thing over and over and over again, it shows that you don't have regard. You don't have the regard for the law of the land. Even if it is speeding ticket, even if it is other little violation, or what we call misdemeanor violation, the fact that you kept on having it on a repeated level. I mean, this particular person I was talking about, it was like having almost 20, 30 tickets. I mean, that shows that there is no regard for the law of the land. Those type of things will constitute negative equity. It will impact negatively in this type of scenario, in this type of application. Again, looking at whether or not the respondent is a business owner. Is the respondent a business owner? Is he or she an employer of labor? Those will count positively. Those will be positive equity. If the respondent is an employer of labor, in fact, it could be argued that because this person is an employer of labor, if you deny the waiver and order this person removed, somebody is going to lose his or her job because he's an employer of labor. And if he has to leave, it means somebody will lose his or her job. An American or multiple Americans may end up losing their job. So that is something that is going to count as a positive equity. In addition, has this person been volunteering? What do you do with your spare time? I know everybody has to work, but at the same time, everybody also have some form of spare time. So what do you do with your spare time? Do you volunteer? Do you get involved? Do you get involved with your community? Do you get involved with your church? Do you volunteer in your mosque? Do you volunteer in your religious organization? Do you volunteer within the city? Do you participate in community activities? I mean, there are so many communal opportunities in the United States where you can contribute your own little quota to the society. So do you get involved in things like this? Those are examples of positive equity. Before I go answer the next question, I just want to expatiate more on this equity scale of justice in determining discretionary consideration. So another thing the court is probably going to look at is family ties. So do you have family ties here in the United States, or are your family ties basically in your home country? So those are, if you have family ties in the United States, let's say your parents are here, your siblings are here, everybody is here, yes, that will also count as a positive equity. That will count as positive equity. And I think I've mentioned okay. Another thing that may also count either as positive or negative is your social status. So social status. Do you get drunk? Have you been cited for driving while under the influence of alcohol? Are you a habitual drunkard? All those things, if yes, those will be negative equity for you. You may not have been convicted of anything. You may not have been been arrested for it. But if you have those records, yes, it will count as your negative equity. So again, as I list all these things, I want you in your mind to start putting them on each side. So whatever point I raised, make a determination and see whether it falls into negative equity or positive equity. So at the end of the day, you put both of them on your imaginary scale and determine which one comes first and which one outweigh the other. Another thing that I also have to say is that the nature of the fraud itself That is another thing that every judge is going to look at before this type of waiver is granted. So what is the nature of the fraud? Again, this is where I mentioned that where the fraud is something that happened out of ignorance, it's not going to count as negative equity for you if you can establish that this was actually based on ignorance. It will not count as negative equity. But where the judge determines that this was a scheme, this was something that was planned carefully. This was not something that happened accidentally. There was evidence of planning, meticulous planning. Then that will count as negative. Again, that does not mean that the waiver will be denied, because at the end of the day, it is the totality of the evidence. It is whatever outweigh the other. It is whether your positive equity outweigh the negative equity. Those are the things that will determine whether or not it will be granted. So if you the more positive equity you present, the better for your case. So if you know that you have some form of negative equity, try as much as possible to, at least for every negative equity, try to present at least 3 counter positive equities to wipe off the effect of the negative equity. So that way, the judge will not have a choice but to approve the approve the waiver. Now, let me read the next question before we proceed. One of two. I got green card through marriage. It was determined during citizenship that it was a sham marriage. I was placed in deportation proceedings. While in court proceedings, my only qualifying relative was my US citizen father, but he just passed away. Do you think he can still be my qualifying relative if I apply for this waiver? Well, sorry about that. Unfortunately, the answer is no. Based on this fact story, yes, you may be eligible for the waiver, but you need a qualifying relative. And if your only qualifying relative, your father, has passed away, you will not qualify for this waiver, because at the time of the trial, at the time that the case is going to be tried, you have to show that you have a qualifying relative. You have to show. Another question? I didn't get you. The last question I have is what I just read. Is there another question? Okay, I'll look at it. Are you the one that sent this or the person that asked the question? No, this is not accurate. Both of them are not accurate. I'm trying to go back to the question. How do I do that? Okay, I think I'm back to the question. Yeah, the question is, I got green card through marriage. It was determined during citizenship that it was a sham marriage. I was placed in deportation proceedings. While in court proceedings, my only qualifying relative was my U.S. citizen father, but he just passed away. Do you think that he still be my qualifying relative if I apply for this waiver? Okay, now you will notice that I paused a little because I was having a conversation here in my office with my assistant here. The question that my assistant brought to my attention is related to this last question and one of the previous questions that I answered. The one that says that I'm a VAWA applicant, that I'm applying for 237A1H waiver, whether I need a qualifying relative. And my answer is yes, you need a qualifying relative. You need a qualifying relative. That is the statutory language of 237A1H waiver. And in this second one, that the qualifying relative died while the applicant, while the application for 237A1H waiver is pending. Now, I want to expatiate further on that. You see, if you understand the way the U.S. immigration law works, you will see that in certain areas, this is one of the complications of legal practice here in the U.S. In certain areas, certain things may be possible. In other areas, those things may not be possible. So if you are applying for benefit, the first thing you need to know is that what is the law, what is the governing law in the jurisdiction where you are applying. In the US, there is only one Board of Immigration Appeal in the entire US, one single Board of Immigration Appeal. However, this same Board of Immigration Appeal apply different standards, different laws to different states depending on the jurisdiction, depending on the circuit under which you are operating. In other words, we are in Texas. Texas is under the United States Court of Appeal for the Fifth Circuit. Now, in certain areas, Fifth Circuit will take a decision that this is a binding precedent. And then another circuit in another jurisdiction, maybe Second Circuit, for example, which is New York side, they can come up with something different. Or maybe Sixth Circuit, which covers areas like Michigan and things like that. They can come up with something completely different. Or even the 10th Circuit, they can have a different rule. So, in my answer today, basically, I am explaining the situation based on the operating principle in the Fifth Circuit, because that is what covers states like Louisiana, Texas, Oklahoma, and some of these southern states. That is the governing principle. However, having said that, you have to determine which circuit are you operating under, because what my assistant was calling my attention to was the ninth circuit? What circuit was that? Was one of the circuits where the court disagreed with BIA that because the qualifying relative died while the application for 237A1H waiver is pending, that the BIA should have approved the waiver despite the death of the qualifying relative. So that is why I believe it is important that I add this additional explanation. So you have to determine under which circuit you are operating. And to be honest with you, if I'm in your shoes and I know that I will be eligible in a particular circuit, I will relocate. if what I need, what will benefit me is available in another state, in another circuit, I will relocate. Immigration law is federal. There is only one law for the entire country. It's not on a case-by-case basis. But when we are talking about precedent, when we are talking about case laws, yes, case laws may differ from one location to another. And usually, that is the type of thing that determines which case goes to the Supreme Court, which case goes to the US Supreme Court. Whenever there are conflicting decisions from multiple circuits, usually the Supreme Court will come in and settle the differences. But right now, there are conflicting decisions on this issue of whether a qualifying relative has to be alive throughout the application process for 237A1H waiver. But I remember that I did one case of this 237A1H waiver in Texas here. I think it was last year. Yeah, I think it was last year. Can you remind me? I don't want to give the client's name on here, but I think it was last year. This name. It was last year, 2022. Okay. Yeah, I remember I did that case on this 237A1H waiver. The qualifying relative in that case was an elderly woman. In fact, on the day of the trial, she was in the hospital. But the judge insisted, excuse me, the judge insisted that he has to speak to this person to be sure that the qualifying relative is alive. So during the trial, we had to place a phone call to the qualifying relative at the hospital, and the judge asked the qualifying relative a few questions, including identity questions to verify that the person is actually who the person claims to be. It was only after the judge verified that the qualifying relative was alive that the 237A1H waiver was granted. This was just last year, this 2022. And to God's glory, that client is a US citizen today, because as soon as the waiver was granted, we resubmitted the citizenship application, and it has now been approved. The client is a US citizen now. So keep the questions coming. I believe I've answered the last question. So if there are no other questions for now, maybe I can keep discussing the issue of discretion, the issue of discretion, what constitutes how the scale of justice could be determined. We can discuss other issues. Keep the questions coming. Keep the questions coming. We still have time. We still have about 35 minutes. Keep the questions coming in. So, talking about factors to be considered in determining scale of justice, again, I think I've mentioned a few factors, but I'm not sure if I've mentioned the value to the community, So talking about value to the community, some people, they believe in going their daily routine quietly, not participating in anything, which is not a crime, is good. But the question is, do you add value to your community? Do members of your community even recognize you? Do they even know that you exist? How many people can give you support letters? How many people can write a review about you, and what will the review be? These are positive factors. If you can get as many people as possible, if possible, even the congressman, the senators, the local, the council officials, the mayor. Do you even participate in local fundraising drives, non-profit organizations, the Red Cross, even your church, your mosque, your religious organization? What is your value to the community? All these things constitute positive equity. Positive equity. What is your ties to the community? Are you easily uprooted? Or is the judge going to look at the enormous cost of having to uproot you within the society? Are you somebody that once they ask you to leave, that's it, there is no impact? Or are you somebody that the judge is going to have to rethink the impact your removal is going to have within the community? If you are a businessman, are you a member of the Chamber of Commerce locally within your society, even within your city, within your state, even nationally? Are people going to be able to rally around you? These are all positive equities. These are things that every judge is going to look at and determine that, okay, if I'm going to remove this person, it's going to be problematic. If I'm going to do this, it's going to cause a lot of problems. So these are the kind of things that you have to show in presenting your scale of justice. So keep the questions coming in. 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 I also have to point out that another thing that the judge will look at is your immigration history. Have you been involved in previous violations? Have you been involved in do you have are you an unrepentant violator of laws? I mean, if they decide to look at your history, maybe when you apply for visa, starting from your home country, maybe there was misrepresentation. Maybe you provided false information. Maybe along the line, you got into the US, you presented fraudulent documents. There's a pattern. You have a long history of immigration violations. All these will be negative equity on your part. There will be negative equity. And to get this case approved, as I said, for every negative equity, you try as much as possible to counter with at least 3 positive equities. It's a matter of presentation. It's a matter of your involvement within the community. And of course, more importantly, it's a matter of using an experienced and a very good immigration attorney. Because all these things you will have only one opportunity to present it. You cannot present a good case on appeal. You can only present a case at the trial of fact, that is at the immigration court level. So whatever you are not able to present at the immigration court, you cannot present new evidence on appeal. That is not the way appeal works. They are going to dismiss your appeal if you have to start presenting something reasonable, something approvable on appeal. You have to present whatever you have at the immigration court level. So that is the way 237A1H waiver works. Please keep the questions coming. We have about 30 more minutes to go. Keep the questions coming in. I believe I've explained it right now, so I'm waiting for questions so that we can keep coming. Okay, there's one question that just came in. Is there any fee to apply for the waiver? Well, when you say any fee, are you talking about, I don't know, whoever sent this question, are you talking about professional fee or are you talking about filing fee? Remember, I did say that this particular type of waiver, there is no form. There is no form for it. And if there is no form, it means there is no payment, no official payment. Of course, the only payment you have is the payment you pay your attorney. And of course, if you have previously paid your attorney to defend you in a removal proceedings, I don't believe you need to pay any additional fee. So for us here in our office, we only charge one fee for removal defense. So once you pay that fee, any relief that we file, if it requires filing fee, you pay the filing fee. If it does not require filing fee, there is no additional charge. So that is something you have to discuss with your lawyer. So keep the questions coming in. Keep the questions coming in. For the benefit of those who join us late, today we are discussing INA 237A1H waiver. It's a form of waiver that is available for legal permanent resident, people who are U.S. Permanent resident, people who have green card. However, to be eligible, you must have obtained your green card by fraud. If you obtain your green card by fraud, maybe you married a U.S. citizen fraudulently, maybe you enter into a fake marriage, or maybe you committed some other form of fraud. We mentioned an example, maybe your parents filed a petition for you as an unmarried child of a U.S. citizen or of a permanent resident. Maybe the petition was approved and you went through the process, immigrant visa was issued to you, but as soon as you got the immigrant visa, maybe your fiancé started mounting pressure. Now you are going to America. Once you go there, you forget about me. We need to get married before you go so that you don't forget me. And then you succumb to pressure. You got married. That, of course, that marriage invalidates everything that has been approved for you. But you enter the U.S. because you already have the immigrant visa and you didn't disclose. But maybe subsequently you file a petition for your husband or for your wife, or maybe you apply for citizenship later, and then in the process, immigration discovered that you actually got married before coming to the U.S. That is considered fraud. So there are a lot of other fraudulent activities that can make someone eligible for 237A1H waiver. But in order to be eligible for this waiver, you have to show that you are actually you actually obtained your green card by fraud. In addition, you also have to show that you have a qualifying relative. But I've said over and over and over again, this is one waiver that you do not need to prove hardship to anybody. No hardship is required. You do not need to prove hardship to anyone on this waiver. You do not need to prove hardship to anyone. when you are applying for this waiver. This is the only waiver that does not require the proof of hardship to the qualifying relative. And of course, we have explained what constitutes qualifying relative. We have explained other, other situations that make someone eligible for this waiver. So we are discussing 237A1H waiver today. So keep the questions coming in. Keep the questions coming in. Keep the questions coming in. So for those who are joining us, those who are just joining us, we have explained all the differences between the statutory requirement and the discretionary requirement. So the statutory requirement is two. You must have obtained the green card by fraud, and secondly, you must have qualifying relative. The discretionary requirement, that one, we did explain that the judge, the immigration judge, because this is a waiver that you can only apply for at the immigration court. So the immigration judge, we have to prepare a scale of justice and now make a determination which one is heavier. Is it your positive equity or is it your negative equity? And that is because the court did set a precedent determining that although this is discretion, the judge has the discretion, but the judge must still meet certain basic threshold in exercising this discretion. And the court have said that in order for the judge to make a fair assessment of his or her discretionary power, the scale of justice must be prepared. Positive equity must be compared with negative equity, and whichever is heavier carries the day. So again, if your positive equity and negative equity is at par on the scale of justice, then your case is probably not going to be approved, except you are lucky to be in front of a judge that is very nice. So usually it is better to present a case where the positive equity will outweigh the negative equity. And of course, we've spent a lot of time trying to explain different samples of how to build positive equities. And of course, what constitutes positive equity and what constitutes negative equities. So keep the questions coming. Keep the questions coming. Keep the questions coming. Keep the questions coming. You can send your questions on our WhatsApp direct number, 817-883-4495. 817-883-4495. That is our WhatsApp direct number for this podcast. But you can also send your question to our WhatsApp on 817-983-4499. 817-983-4499. So keep the questions coming in. We have about 20 more minutes to go. So please keep the questions coming in. Okay, we have a new question. Can the 237A1H waiver also cure other forms of deportability? In other words, if someone is deportable for another reason, could this cure both charges? I don't think so. 237A1H waiver is specifically meant for people who obtain green card by fraud. This does not cure issue of inadmissibility. There's a difference between inadmissibility and someone obtaining green card by fraud. So they are not the same thing. So this particular waiver is specifically geared towards curing the fraud of obtaining green card by fraud. Usually you cannot, something cannot stand on nothing. So if you obtain your green card by fraud, that green card cannot stand. So that is usually the law. But this waiver is available to preserve family unity. According to Congress, the purpose of this waiver is to preserve family unity. Because if you look at it, usually family members are most of the time involved. And that is why the Congress created this particular waiver so as to waive any fraud that is that the respondent committed in the process of obtaining this green card. I mean, this is different from somebody who committed a crime. If you committed a crime and you want to apply for a waiver, that is a different waiver altogether. That is not 237A1H waiver. That is a 212H waiver. That is different. We are not discussing 212H waiver today. That is not the same. So this particular one is only for people who obtain their green card by fraud. This is not the same thing as a waiver for criminal activities. It is not the same thing as a waiver for misrepresentation. Those are 212H waiver. It is different. This is a 237A1H waiver. This has to do with somebody obtaining the green card by fraud, somebody obtaining the green card fraudulently. That is the purpose of this particular waiver, and that is what it cures. So if an applicant is inadmissible on other grounds, such an applicant will have to apply for a separate waiver in that category. This particular one is for somebody who obtained the green card by fraud. So keep the questions coming in. Keep the questions coming in. We still have time. Keep the questions coming in so that we can answer them before we round up. In the meantime, remember to invite your friends and family. We do this every Wednesday, 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. Remember to log in. Remember to invite your friend. Wherever you may be all over the world, remember to log in. It is 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. That is 1 p.m. Eastern Time. That is 10 a.m. Pacific Time. And that is 6 p.m. Nigerian Time. So you call in from anywhere you may be all around the globe, 12 p.m. Invite your family, invite your friend. And also you can subscribe to our channel so that when we go live, you will be notified. It will be unfair on your part to receive all this information free of charge and not share it with other people. So share it with people so that other people too can join us every Wednesday. Keep sending your questions in. We have about 15 more minutes to go. Send your question in. For the purpose of those who are just joining us, if you are just joining us, today we are discussing 237A1H waiver. This is Dr. Olu Asekun's podcast every Wednesday, 12 p.m. Central Standard Time. Today, we continue our discussion of removal defenses. We started the discussion of removal defenses sometimes last month, and I believe we have discussed it now for discussing removal defenses. This is advanced immigration law free of charge. Today, we are discussing INA 237A1H waiver. It's a removal defense that is available for people who obtain their green card by fraud, whether it is fraud of marriage, whether it is fraud or other fraudulent activities, whatever it is that cut off the line of inquiry for immigration to look into. Maybe when you play the DV lottery, you have a child, you didn't disclose it. Maybe when you play the lottery, you are married, but you didn't disclose that you are married. I mean, anything that you did that was not right at the time that you were applying for green card, at the time that you obtained the green card, if it turns out that immigration found out that you are actually fraudulent, then this waiver is available for you. That is what we are discussing today. And we have discussed the requirement. There are basically two statutory requirements and then one discretionary requirement. The statutory requirement is that one, you must have obtained your green card by fraud, and two, you must have a qualifying relative. We have also explained what constitutes qualifying relative. Qualifying relative is a U.S. citizen or a permanent resident family member. Now, family member for immigration purpose is different from family member for in English dictionary. For immigration purpose, family member means your parent, your spouse, and your minor children. Your parents, your spouse, and your minor children. They must be U.S. citizen or a permanent resident. That is what qualifying relative means for this purpose. And they do not need to prove any hardship. They do not need to prove any hardship on themselves or on their qualifying relative. So those are the statutory requirements. As for the discretionary requirement, the court has said that for immigration judges to make a discretionary determination, they must create a scale of justice and put the positive equity on one side of the scale, the negative equity on the other side of the scale, and weigh it. So whichever outweigh the other gets the blessings of the immigration judge. So we have explained the kind of things that constitute positive equity and the kind of things that constitute negative equities. We have spent a whole lot of time explaining all that. So keep your questions coming in. If you just join us, send in your question based on what you oh, okay. I think I have a new question. Keep sending the question in. We still have about 12 more minutes to go. And any question that we receive before we close at 2 p.m. Central Standard Time, that is in about 12 minutes. Any question that comes in, I promise I will answer before we end today's program. Okay. Next, the question. Due to this being a discretionary waiver, is it possible to be denied even though being qualified? What can be done if IJ denies the waiver? Can it be appealed? Well, I'm not sure whoever sent this actually understood what we explained. What I explained is that there are statutory requirements and then there is a discretionary requirement. Of course, for somebody who meets the statutory requirement, that has already given you 50% of the mark. If you meet the statutory requirement, in other words, if it is true that you obtain your green card by fraud and you also have a qualifying relative, you already met at least 50% of the pass mark. Now, the other side is the discretionary aspect. Yes, it is possible if the judge can pinpoint the negative equity, especially if in the judge's analysis, if your negative equity outweigh the positive equity. I've said it that although this is discretionary, the court has made it very clear the factors to consider in making a discretionary determination. And what are those factors? That the positive equity and the negative equity both of them must be balanced on a scale of justice. So it is not something that the judge can just look at the negative equity and deny the case, except the negative equity is so overwhelming. Maybe you have one serious criminal offense. I mean, for example, if the applicant maybe was convicted of terrorist-related activity, that would be a major concern because that would be a public policy issue. Yes, that may override multiple positive equities and the case can still be denied. You are right. However, if it is denied, do you have a right of appeal? Yes. This is an application that can be filed before an immigration judge. So every decision of an immigration judge is subject to appeal to the Board of Immigration Appeal. It is subject to appeal to the Board of Immigration Appeal. And because this one has a statutory element in it, even if the Board of Immigration Appeal denies it, the applicant or the respondent still has the opportunity to appeal further to the circuit court for a review of the Board of Immigration Appeals decision. So it is not a case where the IJ, immigration judge's decision is final. No, you have a right of appeal. But again, the discretionary matter, it is always good to present an overwhelming positive equity. So if you know that you have a negative equity or you have multiple negative equity, try as much as possible that for every negative equity, try to present at least 3 positive equities to wipe off the effect. And in doing that, one thing I will say is that even if the law does not require that a qualifying relative show hardship, if you know that you have a negative equity, especially if you have more than one, if you have multiple negative equities, if you know that your qualifying relative have some fundamental hardship factors, present it. It will help your positive equity as well. For example, if your qualifying relative has some medical challenges and you can show that you are the primary caregiver, even though it's not a statutory requirement, it will be a positive consideration in your favor if you show that you are the primary caregiver, because whatever will affect other people in the process of getting you removed is something that the court will consider in making a discretionary decision. Okay, another question. Years ago, when applying for asylum, I used a fake birth country. Later, I got a green card based on marriage. Is it possible to be granted the waiver in this case of identity fraud? I'm trying to understand what the fraud is, because if you apply for asylum based on this fact, if you apply for asylum based on this fact, you didn't get your green card based on the asylum. So I don't see how that fraud led to your green card. I mean, from this fact, you got green card based on marriage. So I don't see the fraud here. Whatever you did with the asylum, that is not what led to your permanent residence. So you may not be eligible for this waiver, because the first statutory requirement for this waiver is to show that this green card we are talking about, you obtained that green card by fraud. So looking at this fact, I mean, years ago, you used fake back country in applying for asylum, but you didn't get your green card through asylum. So that is not getting green card by fraud. According to your fact, you got the green card based on marriage. So I don't see the fraud here. So there's no fraud here that is linked to your green card. So if you apply for citizenship and they brought up the issue of the fake document regarding your asylum, and if they put you in removal proceedings because of that, you have to apply for some other form of relief, not 237A1H, because you will not be eligible for 237A1H based on this fact. In order to be eligible for 237A1H, the green card itself, your green card that you have, must have been obtained by fraud. Okay, there's a continuation. Yeah, I'm waiting for the continuation. Okay. The information has to be consistent, sir. So it was wrong on the green card application. Maybe I'm not understanding your question, because I still believe that this is not eligible for 237A1H. Let me say this. When I was explaining earlier, especially when I was talking about other forms of waivers, we have a waiver for misrepresentation. We have a waiver for fraud. So what you are stating here, in my opinion, is talking about misrepresentation. Is talking about fraud. That is not what 237A1H is talking about. 237A1H is talking about you obtaining your green card by fraud. That is different from you having committed fraud along your immigration path. Of course, if you presented false information in your asylum application, that is misrepresentation. If you presented a fake country or whatever inconsistent information you provided, that is misrepresentation. That is fraud. There is a separate waiver for that. That is called 212H waiver. That is not what we are discussing today. 212H waiver, that is a waiver for fraud. That is a waiver for misrepresentation. That is different from 237A1H waiver. 237A1H goes to the root of the green card itself. It goes to how you obtain the green card. I mean, according to this fact, you got your green card based on marriage. Was that marriage fraud? Was that marriage legit? Did you do something that was fraudulent regarding that marriage? Because if you obtain your green card through marriage, it means that the U.S. citizen spouse filed a relative petition, I-130 petition on your behalf. Was there anything that was fraud about that, about the marriage? That is what qualifies you for 237A1H. But if it was about misrepresentation, that is a 212H waiver. And that has a different requirement. It's not the same requirement. So, I believe that I still stand by my answer. Based on this fact, this person is not eligible for 237A1H waiver. This is not a waiver that is meant to cure misrepresentation. This is not a waiver that is meant to cure fraudulent document or fraudulent activities or something. No, that is not this waiver. That waiver is 212H waiver. This one is if you obtain the green card by fraud. They are different. So the only way you will have been eligible for this waiver is if the marriage upon which you obtain your green card, if that marriage was a fraudulent marriage. That is the only thing that can qualify you for 237A1H waiver. Other than that, all you will be eligible for, all you can apply for, is a 212H waiver. Of course, for 212H waiver, not only will you need to have a qualifying relative, but your qualifying relative must be able to show extreme hardship. Extreme, note the word, extreme hardship. In other words, it is not going to be a regular hardship that a regular person will be eligible for. It has to be a form of hardship that is beyond normal hardship that is attached to deportation. It has to be a serious one. That is why the statute used the word extreme. So you have to show extreme hardship. But for this waiver, you are not even required to show any hardship at all. So this is a waiver that is available for people who obtain their green card by fraud. So I believe I've been able to answer this. Since there are no other questions, I think we'll be rounding up. But before I do, I want to tell you, thank you for joining us today. But remember to always join us every Wednesday, 12 p.m. Central Standard Time. Here we answer immigration questions free of charge. We have been discussing removal defenses for the past 6 weeks or more. And by God's grace, we are going to continue to discuss it. We're discussing removal proceedings. Again, we will be available at the RCCG convention on Friday, June 16, 2023, in Dallas. By God's grace, we'll be making presentation. So if you have questions that are not answered during any of our podcasts between now and then, you can come to the convention with your questions. We'll be there with a complete team from our office. I will be available to answer questions. Attorney Toyosi will be available. We will have Marisa there. We will have Kim there. At least not less than 4 members of our team will be at the convention. Please remember to join us. And for those who are not able to join, I'm not sure if there will be an opportunity to stream it live. If there is, then you can join live. If there is none, well, those who come to the convention will benefit for it. In the meantime, we'll continue our removal defenses going forward. It's a series that we want to end. And by God's grace, we'll probably be discussing 1 year deadline. 1 year deadline. Asylum 1 year deadline. That is the topic we'll be discussing next week by God's grace. 1 year asylum, 1 year deadline. That will be our topic for next week by God's grace. Asylum 1 year deadline. That is a topic we'll be discussing based on high demand. There are lots of people who apply for asylum having stayed in the U.S. for more than a year. So we'll be discussing asylum 1 year deadline by next week by God's grace. So until then, remember to invite your family and friends. Again, we are doing this free of charge. We are not charging people, and it will be unfair on your part if you get all this information free of charge and you keep it to yourself. The only thing you can do to encourage us is to invite your family and friends, log into our YouTube channel or Facebook, subscribe to our channel so that as we go live, you will also be notified. Thank you and God bless you. See you next week. Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work because like I told you, I'm like a member of this family, and call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I was okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. So okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in her face and we were able to get her substantial amount of money from the insurance company. Even after paying all her medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, Nigerians, you know how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own, and we all celebrated. It was a good thing.
Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work. Because like I told you, I'm like a member of this family. And call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I announced, okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. So, okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in our face and we were able to get her substantial amount of money from the insurance company. Even after paying all our medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, Nigerians, how we react to issues. I was rolling on the ground, thanking God, this, that, not caring what I was wearing or who I was looking. But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own. And we all celebrated. It was a good thing.
Another interesting thing